In California, it's illegal to flee the scene of an accident without stopping and giving your information. And in looking at hit and run, the first thing I want to talk about is what your duties are if you're in an accident in the state of California. If you're in an accident and it's only property damage that's caused, then your duty is to stop at the scene and provide your name and current address, and upon request, show them a copy of your driver's license and your car registration. If you're in an accident with only property damage, but let's say you hit a parked car and the other party's not present, then you're required to write down your contact information and leave it in a conspicuous place on the other person's property. Finally, if you're in an accident and somebody is injured, then your duty is not only to exchange information, but also to render reasonable aid. And usually that means calling 911 and waiting to make sure that the person gets treated by the paramedics. Some people ask us, what if I was not at fault? What if the other person was at fault in the accident? And it really doesn't change your duties. So if you're in an accident, even if the other party is 100% at fault and you're ultimately not going to face any liability, you still are required to stop at the scene and exchange information. So a hit and run could be filed as a misdemeanor or a felony. If there's only property damage involved, then it can only be filed as a misdemeanor, and the maximum penalty is 6 months in jail. If somebody is injured, if it's a hit and run with injury, then it becomes what we call a wobbler. That means it could be filed as a misdemeanor or a felony. And if you're convicted as a felony, you could face up to 4 years in state prison, as well as a mandatory 1-year revocation of your driver's license. Now, all of that said, as serious as hit and run is, we find that a lot of innocent people get wrongly accused. First of all, we've seen many situations where a person doesn't realize that they're in an accident. So it may be a busy road, it may be very noisy, and there's only slight contact with the other vehicle. Oftentimes, you don't even realize that there's been a collision. And if you honestly didn't know there was a collision, then it can't be, you're not liable for hit and run. Also, we see many situations where a person is frightened to stop, and reasonably so. Maybe they're in an accident and an angry crowd of people gathers around, and they feel that it would endanger their safety to stop at the scene. And so they flee the scene for that reason. Well, that can be a defense. However, it is incumbent on the person at that point to contact the authorities as soon as possible and report the incident. Finally, the prosecutor, in order to convict you of hit and run, has to show more than the fact that your car was involved in the accident. So it may have been a situation where somebody got the license plate to your car and the authorities come and talk to you, but just because it was your car, that doesn't mean that you were driving. And the prosecutor ultimately has to prove beyond a reasonable doubt in court that you were the driver. Many times what they'll do is the police will go and get your photograph that you have on file with the DMV and put it in a photographic lineup and show it to witnesses at the scene and see if they can identify you in this what we call a 6-pack photo lineup. If the witnesses can't identify you, then really the prosecutor has very little case. Here at Schaus Law Group, we've had a great record of success over the years in defending clients accused of hit and run, and ultimately getting the charges reduced or dismissed. If you're in one of these situations, we invite you to contact us, tell us your story, let us investigate, let's see what we can do for you.